Good afternoon, folks. Welcome to Ilsa's webinar. We're going to get started in a few moments. We'll give folks a chance to log in. Welcome. We're glad you're here. Thanks to everyone who's joined so far. Welcome to this afternoon's webinar. As we wait for folks to join our meeting room, please make sure you're muted if you don't mind. And we will get started in just a moment. We'll give folks a chance to get in the room. Hi, everyone. As you're logging in, hey, feel free to introduce yourself in the chat. And I always love to see what state people are calling in from. So feel free to add in the chat. Where are you from? Where are you calling in from? I'd love to see where folks are from. Take a moment, go ahead and put that in the chat. It's always fun to see. Oh, Des Moines. Washington State, Green Bay, St. Louis, Memphis, North Carolina. Hey, Chris. Harrisburg, Rochester. Nice. All right. Oh, another person from Des Moines, BC International, Arlington, Houston. Wonderful. All right, everyone. Well, we have a big agenda today, so we are going to go ahead and get started. I'm sure we'll have other people continuing to join as we go through today's discussion. Let me introduce myself. Hi, everyone. I'm Becky Blenderman. I am part of ILSA, the Immigration Legal Services for Afghan Arrivals Group, and I'll be your facilitator today. So welcome. Welcome to those of you. I see some familiar names of folks who have been here in previous month's webinars, so thanks for joining us. And thank you if you're new. If you want more information on ILSA and joining our network, please put a little note in the chat, and I'm sure Bridget, who's on this call, would love to follow up with you. So welcome, everyone. Today's webinar, our topic is providing family reunification services. We have a couple wonderful guest speakers for you here today. Just a couple of housekeeping notes. We are recording this webinar. It'll be available in the future from our peer networking hub. So those of you who are part of the network already know about the peer networking hub. You'll be able to find the webinar there. Secondly, we want this to be an interactive webinar. Your participation is encouraged. Please put questions in the chat. We will have time for questions at the end, I believe, but please make sure you're on mute when others are speaking. That would be great. Again, thoughts, comments are encouraged. If you're having any technical issues, you can reach out to Bridget Ott, who is here on this webinar and can do her best to assist you. And finally, at the end of today's session, we're going to put a quick evaluation link in the chat and we will send it out after the webinar. We would love it if you could fill that out. It takes about 3 minutes at most to fill out that survey, but we'd love to hear it because we want to know what are topics you want to hear about and how effective was the material you heard today. So with that, let me introduce our speakers. Well, I'm going to just show our agenda. I'm not going to go through all of these individual topics, but let you scan through this. These are some of the topics that we're going to be covering today in our agenda. So all of these different options. And then at the end, we're going to walk through some common scenarios that you may see. So that's our agenda. We have 2 guest speakers today. I'll introduce them both. First is Chris Cheney. Chris is our ILSA Western Region Coordinator. And he serves also as a regional technical advisor for the International Rescue Committee. And I said Western Regional Coordinator for ILSA. Chris is our first speaker. Our second speaker, if you just want to flip forward, is Pete Lucier, Operation Coordinator for Evacuate Our Allies Operations Center. Hi, Pete. Thanks for saying hello. And you'll hear from both of those gentlemen today. And feel free to add on to your introduction. I won't read through the slide, but some pretty accomplished folks we have here for your facilitators. So with that, I am actually going to turn it over to Pete for digging into the content. Go ahead, Pete.
Thanks so much, Becky. Thanks everybody for coming. She said, my name is Pete Lucier. I work with the Evacuate Our Allies Operations Center, which is part of the EOA coalition, and specifically I work for Human Rights First, where we're kind of based out of. So just give you a little overview of how today's going to go. I've been doing this since August of 2021. I got involved as a volunteer during that time, and here 2 years later, I'm doing it kind of full time with EOA Ops. I like to think of relocation as kind of happening in two parts. There's the paperwork side, and then there's the logistical kind of operational side. That first part, the paperwork side, is going to look very traditional to kind of traditional immigration law and moving applications along through the various things. Chris is going to cover all of those today. If you look at the chart here, you're going to see a lot of different categories, and these are kind of what you're going to find among people who are presenting to you in your offices and clients. They're going to fall into one of these, either U.S. citizens with family members, LPRs, people who are in various stages of the SIV process, parolees, the refugee categories of P1, P2, or P3, and then also asylees who are filing follow to join petitions in the I-730s, as well as a few others. So what those look like and how to get those sufficiently advanced to kind of a terminal phase, whether that's actually issuance or to the documentarily qualified stage, because there's no embassy in Afghanistan. Chris is going to kind of cover some of those things and what those looks like. And then the second half, I'll come back on, and we're going to talk a little bit about if you have if the beneficiaries of these various petitions are still in Afghanistan and there is no embassy, what happens next? How do I get that person in a place where they can actually physically relocate to the United States? And we'll talk a little bit about what the CARE system looks like and what those relocation assistance flights look like. That's where someone from Kabul is going to go to a third country, but that flight is going to be controlled by the US government, and they're going to be able to finish processing there. And then we'll talk a little bit, won't cover much though, about kind of self-affected relocation. So that would be if somebody voluntarily moves themselves to a third country, usually Pakistan, and some of the logistical concerns of what that looks like. So the paperwork trail up to usually the documentarily qualified stage, and then from there, kind of the movement phase. And those will be our two parts, and hopefully that'll cover most of the situations that y'all are running into. That's what it's going to look like. Chris is up first, and he's going to talk about some of these various categories and what they look like. So Chris.
Wonderful. Thank you, Pete. And thank you, everyone, for joining us today. First, let's talk about your clients who are U.S. citizens and have Afghan family members that they wish to bring to the U.S. U.S. citizens may file petitions for immigrant visas on behalf of certain family members. This can be done on behalf of spouses, parents, and children who are unmarried and under age 21. This first group of beneficiaries is known as immediate relatives. Their immigrant visas are not subject to a quota, and therefore they will be immediately available. U.S. citizens may also file petitions on behalf of their siblings, as well as their unmarried adult children. And these two are considered preference categories, and they are subject to annual quotas, and therefore they may have to wait, for a visa to become available. So the petition for family member is filed on Form I-130 with USCIS. Evidence must include documentation proving the family relationship between the petitioner and the beneficiary, such as birth certificates or tazkirahs. The second part of the application is the immigrant visa application, and this is filed on Form DS-260 with the Department of State. The National Visa Center is part of the DOS, and they help gather the necessary components of the immigrant visa application. In family-based petitions, The petitioner generally needs to prove the ability to financially support the beneficiary. And this is done using Form I-864, the Affidavit of Support, which is also part of the overall immigrant visa process. So the NVC must receive all of the required evidence, including the I-864 evidence, such as tax transcripts, before deeming the case to be documentarily qualified for an interview. And then they forward it to the appropriate embassy or consulate for the interview. Okay, next slide, please. So here we have a chart that describes the steps taken by US citizens when they petition for their qualifying relatives. There's a note there that some fees might be fee exempted. Both the I-130 fee as well as part of that $665 fee is fee exempted for certain Afghans. We're going to get into more details about fee exemptions in a couple of slides. Next slide, please. So this slide here we have an excerpt from the Department of State August 2023 Visa Bulletin, the final action dates chart for the family preference categories. So let's take a moment to talk about priority dates and how they work in conjunction with the Visa Bulletin. A petition's priority date is assigned using the date the application was received and accepted by USCIS. For family-based petitions, the priority date, of course, is based on the acceptance date of the I-130. Certain categories of family-based immigrant visas are subject to the annual quotas. And if they become oversubscribed due to popular demand, this results in what's called a backlog. The Visa Bulletin is basically a monthly estimate of how long these backlogs take. So if we review briefly the family preference categories shown here, F1 is for unmarried sons and daughters of U.S. citizens. F2A, spouses and children of LPRs. F2B, unmarried sons and daughters 21 years or older of LPRs. F3 for married sons and daughters of U.S. citizens. And the F4 category is for brothers and sisters of U.S. citizens. The dates you see listed on the chart, these are called the cutoff dates for each of the categories. If a petition's priority date falls before the cutoff date listed on the Visa Bulletin, then the beneficiary is eligible to proceed with the application for permanent residency. We should note that the Visa Bulletin has two charts each for the family-based and employment-based categories. There's the final actions date chart, and then there's the dates for filing applications chart. As the name implies, the dates for filing applications chart is used to indicate when an immigrant visa or when the applicant should be notified to begin the process of submitting the required documentation to the NVC. On the other hand, the final actions date chart indicates when the immigrant visas are available for issuance. So if a petition's priority date falls after the cutoff date shown on the final actions date chart, then by law, DOS is not able to issue the immigrant visas. Unfortunately, this past year has seen what's called a regression in the cutoff dates for the F2A category. That means the dates have been moving backwards. Now, reminder, F2A category includes spouses and children of LPRs. Prior to April of 2023, for many months, the F2A category was all current, which means that there was no backlog and residency applications could be filed immediately. Now, as of April and leading up until this month, we see that Afghans in the F2A category must have a priority date of October 8th, 2017, or earlier, in order to proceed with their residency application. Okay, next slide. It's very important to note that certain Afghan nationals are eligible for fee exemptions. This means that they automatically do not need to pay a fee for the underlying application. So in other words, they don't even need to apply for a fee waiver. As of today, this rule will remain in effect until September 30th, 2023. Now, the fee exemption applications for Afghans include parole-based I-765 EAD applications under category C11, the parole category, I-485 applications for SIVs, as well as any associated I-601 waiver application. Also includes I-130 petitions filed on behalf of Afghans with a visa immediately available, as well as any 601 waivers associated with that I-130 that's been approved already. Now, we should note here that currently this I-130 fee exemption only applies to immediate relatives of U.S. citizens because, as we just discussed, spouses and children of LPRs in the F2A category are now facing a backlog in the visa bulletin. So this means that they must pay the $535 fee when filing their I-130. Now, if the F2A category advances back to current, then the fees for Afghan F2As will once again be exempt. Also on this list, we see the I-824 application for follow to join, and we're going to be talking about that one shortly. And finally, the USCIS immigrant fee, which costs $220, and it covers basically the cost of the green card production for those who come here with immigrant visa. So that is also waived for F2As. Next slide. Okay, next, what if your client is a lawful permanent resident? Well, then they can petition for their spouse and their unmarried children under the age of 21. They can also petition for unmarried adult sons and daughters. However, unlike US citizens, LPRs cannot petition for parents, siblings, or married children. Okay, next slide. So next, let's talk about follow to join procedures. If your client is an LPR, including SIV, they can bring their spouses and unmarried children under 21 years old without having to file an I-130 petition. Now, there's two possibilities here. First, if your client came into the US with an immigrant visa, then the spouse and children can proceed with their immigrant visa applications without any need to involve USCIS. They merely need to contact the National Visa Center and notify them that they're ready to apply for their immigrant visas. Second, if your client came into the US without an immigrant visa and they obtained their residency status using an I-485 adjustment application, well, then you need to get USCIS in contact with DOS. And this is done by filing Form I-824. The purpose of the I-824 is for USCIS to inform DOS that your client's residency has been approved. If your client tries to tell DOS that the adjustment was approved by sending on their own a copy of their green card or a copy of their I-797 approval notice, well, DOS won't take it. They'll say, no, we need to actually see proof directly from USCIS, and this is done via Form I-824. Now, it's important to note that the follow to join options are available only if the spouse was married to your client before your client received residency status. And the same holds for children. Only children who are born before your client receives LPR status can do follow to join. Next slide. Okay, here we have a similar chart for the LPR category, which kind of reviews what we were just discussing. And of course, these slides will be available after the webinar for your reference. Next slide, please. Okay, next, let's talk a little bit about the Child Status Protection Act. This allows derivative children to use what's called an adjusted age rather than their actual biological age when determining whether they remain eligible as a derivative once they pass 21 years of age. This rule applies to a variety of immigrant categories, including family-based SIVs, refugees, and asylees. The adjusted age is measured by reducing the amount of time a petition is pending from the child's biological age on the date the visa becomes available. So the amount of time a case is pending is it's simple. It's measured from the receipt date to the approval date. If a visa is immediately available when the petition is approved, then the amount of time the petition was pending is subtracted from the beneficiary's age on that date of approval. Now, if your calculations reveal an adjusted age of under 21, then you're in luck, and the age is frozen for purposes of derivative eligibility. It's very important to note, however, that the child must seek to acquire the LPR status within 1 year of the petition's approval. Or if the priority date isn't current at the time of approval, then the seeking to acquire must occur within 1 year of when the priority date becomes current on the final action date chart of the visa bulletin. Next slide. How does the CSPA work in SIV cases? The answer to this question remains slightly murky due to the changes to the SIV procedure that occurred last year in July of 2022. Previously, the I-360 petition was the operative petition used for CSPA age adjustment calculations. Now we use the form that's part of the Chief of Mission request, the DS-157. We should note that we're still waiting on written guidance from DOS on this matter, but I think there certainly has been confirmation during several public engagements that the DS-157 is now being used for the purpose of CSPA. In a nutshell, the amount of time the COM is pending is subtracted from the child's actual age on the date the COM is approved. So if this calculation results in the adjusted age of under 21, then the child must seek to acquire in one of two ways. So for principals that entered with an immigrant visa, the DS-260 must be filed within 1 year of COM approval. And for principals that adjusted status, the form I-824, follow to join, is used for seeking to acquire purposes. This is a good place to remind everyone that the I-824 can be filed concurrently with the I-485. So for asylees and refugees, it's a little simpler. If the I-589 or the I-590 is received by USCIS before a dependent child turns 21, he or she will continue to be treated as a child for future applications, including refugee processing, I-730 follow to join applications, adjustment applications, and of course, this remains true as long as the child remains unmarried. Next slide. So this brings us to the next category. What if your client is a refugee or asylee? As we just discussed, their spouse and unmarried children under the adjusted age of 21 can be eligible for follow to join benefits using form I-730. The I-730 should be filed within 2 years of becoming a refugee or asylee. Once USCIS approves the I-730, then DOS will proceed with contacting the family members to finalize that process. Next slide. The P3 category of the U.S. Refugee Admissions Program allows persons granted refugee or asylum status in the U.S. to petition for their parents, spouses, and unmarried children under the age of 21. This is done using form DS-7656, the Affidavit of Relationship, AOR, which must be filed within 5 years of becoming a refugee or asylee, and in certain situations could be filed by an LPR or even a U.S. citizen who previously held refugee or asylee status. To qualify for access under the P3 program, an applicant must generally be outside of their country of origin, be registered or have legal status in that country of asylum where they're residing, must have had an affidavit of relationship filed on their behalf by an eligible family member in the US, and must have been cleared for onward processing by USCIS. Next slide. So turning to Afghan parolees, Afghan parolees can apply for family reunification assistance for spouses and unmarried children under the age of 21 by submitting the form DS-4317, 4317, to the Department of State. You'll need to enter information from your client's EAD card or other documents and provide documentation demonstrating their relationship with their family members, such as tazkeras or marriage certificates. Next slide. And here we have a similar chart for your reference. We should note, as of last night, I haven't checked this morning, the DOS website notes that the DS-4317 is in the process of being updated. Applications that were already submitted prior to July 31st, 2023 are ongoing. Applications submitted after July 31st, 2023 will somehow receive notification that they should be using the updated system. DOS expects to resume accepting applications using this revised form by sometime this month, I think, by the end of August of 2023. Next slide. Okay, finally, let's talk briefly about unaccompanied Afghan minor clients. An unaccompanied child is defined as a child who has no lawful immigration status in the US, has not attained 18 years of age, and has no parent or legal guardian in the US that's available to provide care and physical custody. An unaccompanied Afghan minor is an unaccompanied child who was evacuated from Afghanistan since August of 2021. ORR coordinates closely with DOS and DHS to effectuate a safe and timely reunification with their parents, legal guardians, or primary caregivers. Next slide. And these relocations are coordinated by the Department of State's Office of the Coordinator for Afghan Relocation Efforts, the CARE team, which handles the logistics of relocating eligible Afghans to overseas care processing centers. So I'm going to stop there now, and I'm going to pass it over to Pete for the next part of the presentation. Thanks.
Chris and Pete, we do have a couple of questions. Do you want to stop and take them now, or would you like to wait?
Pete, it's up to you.
Chris, I think we're a little ahead of where we need to be, so I think it might be a good break to take some questions a little closer to maybe where they're popping up, if that sounds okay.
That sounds great. And we have one from Rebecca Nidlock. If we want to take that first, if you want, I won't read the question aloud. I can let you take a look at it in the chat. I'll start. If an SIV grantee did not list all of his derivative children on his filed SIV application, they were abroad or born out of wedlock, can he now seek for them to immigrate as derivatives? So on and so forth.
Sure, I can do it. It's just a general answer to that question. Generally speaking, if a petitioner were to, for example, leave off names of children in earlier parts of a petition process, that doesn't necessarily mean that those children are no longer eligible to be child derivatives. And frequently what happens is later on in the process, for example, if you're submitting your I-824, or sometimes if the child is submitting an I-485, there would almost likely be a request for evidence where the petitioner would have to not only demonstrate the relationship with the child, but maybe even take extra steps. Sometimes we'll see a request for DNA evidence be submitted in situations where children were left off prior applications. But it certainly doesn't mean that they're no longer eligible as child.
And just to double, and because I think and maybe this is the same, Chris, I don't want to, but I believe the situation here is so that the SIV is a grantee, so they already immigrated to the United States, and the application is fundamentally closed. So would that still apply if he's already entered on that SIV and with other derivatives, even after that fact, they'd still be able to add additional. Because I know later on in the process, if they weren't listed initially on a DS-260, there's ways to add them before that actually gets to issuance. But if the family already immigrated, but there was earlier children, is that still something that can be amended on an SIV application that's kind of already closed, or is that an I-130 app?
Good question. And usually it comes down to I guess the main hurdle is whether or not the child was born before the principal became a resident. And if they can demonstrate that the child was, born before the principal became a resident and otherwise qualifies as a child derivative, they would still be able to proceed with a residency application as their child.
All right, let's take one more question from Zaina Noor. It's like the first question. A question around what embassy should be listed on form. Should it be Kabul or another embassy?
Do you mind if I take this? If you have other.
Please, yeah, go ahead.
Sure. So, it's a good question, Zaina, and the answer is a little bit. It depends. So, generally, for those who are going to go through the CARE pathway, so if and sometimes that's not always clear, but it is, I will say, easier and requires less kind of paperwork and fixing on the back end if, as of the time of application, if the client is or the beneficiary is intending on trying to use the CARE pipeline, they should continue to list the Kabul embassy as the embassy of chargeability or the consulate of chargeability. I know that seems counterintuitive because there is no embassy of chargeability, or there is no embassy in Kabul. But what that does on the back end, there's a system called Falcon, and that really is what deals with the CARE flights. And it's drawing from and a lot easier to kind of upload and to identify who these folks are to then get them into the flight manifest queue. If the first place it's looking is at everybody who's been assigned to, U.S. Embassy Kabul. So if they're physically in Afghanistan, nothing is going to go wrong if they put Kabul, and they can later transfer that over. Whereas if you aren't sure and you list ISL and you're not quite there yet, you may have to try and bring it back or notify CARE in a different way that while that's the embassy that they selected, they're actually still physically in Afghanistan. So to keep your options open, I would say, and this is not necessarily like a legal question, but kind of a logistical question and a what's best and what's going to work best for the particular client. But if they're physically in Afghanistan, I would say stick with listing Kabul on there, if that makes sense. And hopefully it answers it. Every case is going to be a little bit different, but generally starting there. And then if you need to transfer it later for the CARE pipeline, all of the case transfer mechanisms are going to happen. The US government is going to do that. It's not something that the client has to initiate. For self-affected relocations, they're going to have to, request a transfer on their own, but that's doable and usually happens pretty quickly at this phase. So that's a long answer, but generally sticking with Kabul, even though it doesn't exist, is still just fine. And hopefully that answers the question.
Yeah, I totally agree. And before we move on, I saw one more question, which is kind of related to the question I was answering. So I thought we could knock that out really quick before proceeding. And that is from Belinda relating to Rebecca's question. She says that her SIV's client is unlisted, but it's also a quote adopted child, even though there's no legal adoption yet to take place. Does this change the analysis at all? And it kind of does. At this point, if there has been no legal adoption yet, and the principal has already obtained their residency, that means the parent-child relationship did not occur or did not take place yet when the residency was approved. So they're going to have to use an I-130 petition. Okay, should we move on? Back to you, Pete.
Yeah, awesome. Thanks, Chris. Can we, is the screen share, is it zoomed in for everybody else? Or am I wrong? That looks a little better. Okay. Yes, it is zoomed in for everybody else as well. Okay.
Yes. No, I'm seeing the regular Zoom screen. Are folks having trouble seeing the screen? Can you see the full PowerPoint slide? Yes. Okay.
You guys can. Okay. All right. That's good.
Yeah, okay.
I'm sorry. I'm just rearranging. I'll just get my own. Just make sure I'm doing. All right. That'll work. All right. So what we just went over was kind of like the first half. So we used to talk about in the early days, especially kind of visa first thinking when it comes to relocation. So before, somebody might come to like the op center and be like, oh, how do I get this person out? Even if it's an urgent case, even if there's medical issues, even if there's only things, starting with that visa or refugee or I-730, it's the various different entry documents first, and kind of having those progressing is always going to make work on the back end, kind of where I live in that relocation side, easier. So that's the first half of everything that needs to happen. And most of the time, in fact, at this point, kind of all of the time, one of those pathways is going to have to be sufficiently advanced, kind of a terminal phase. It has to be kind of like interview ready before CARE is going to consider somebody relocation eligible. So what is CARE? How does that work? How are people currently getting out? That's what we're going to talk about a little bit. CARE, the coordinator for Afghan relocation efforts, is offering assistance. What that looks like currently is about 2 flights a week. We're currently on a pause. That's happened 2 or 3 other times. So we're hoping that those resume. Usually there can be some diplomatic issues that run into there, but generally under normal operating circumstances, we're looking at 2 flights a week from Kabul to various other third countries that have kind of pop-up embassy services. So people with sufficiently advanced applications can kind of register and get in line in this manifest queue, can get on those flights eventually, go to that third country, finish their processing, and then from there, it's either self-funded flights to the US, or if they're eligible for IOM, they can use IOM loans to travel. Conducting interviews of Afghan visa applicants. Yep, decision to deny a visa, it has to happen at the interview. And yeah, the last part there is an important one on the slide. So if you look at the relocation manifest eligibility chart that was at the beginning of the screen, and I listed some links there, what you'll notice under US citizens and other things, there used to be a caveat that if a US citizen was in Afghanistan prior to the fall of Kabul, prior to August 15th, 2021, or August 1st, 2021, if they were physically there and they had otherwise eligible derivative family members who were with them, those other family members were allowed to travel prior to the documentarily qualified stage on their I-130 or various petitions. That only applies if that U.S. citizen or LPR was in Afghanistan prior to August 1st, 2021. What that means is we saw a bunch of unfortunate cases of what we call returners, U.S. citizens or LPRs who returned to Afghanistan hoping that their physical presence in the country would allow their family members to travel with them kind of faster. That is not the case, and will not be the case going forward. So if you have any U.S. citizen or LPR clients who are considering returning to Afghanistan, thinking that it's going to speed up the process for their family members or derivatives, that's not the case. In no way does returning to Afghanistan, which could put that LPR or U.S. citizen in a considerable amount of danger, be considered, and it's not going to move them up the manifest queue any faster. So just the note for that. So 2 flights a week. How do people get on them? And U.S. citizen returners won't help. Could we go to the next slide? Sure. So those flights happen. There's some various requirements that kick in. If we imagine that a visa application has, say, 15, and that's a made up number, pieces of information, in order to get on a care flight, there's going to need to be kind of maybe 30 pieces of information. And collecting those additional 15 happens after the fact, but that process doesn't start until somebody gets to that documentarily qualified stage. The process of what that looks like, on the right side of the screen, you'll see Falcon. Falcon is a Salesforce CRM, a customer relation management software program. We're now at the point where all of those categories talked about earlier, whether those are I-130s, SIV applications, those didn't used to talk to Falcon. Now they do, and including I-730s, which is the most recent one that is now Falcon compatible. So all of these different applications, once they get to that documentarily qualified stage, that information, along with the 15 pieces of information they come with, is automatically uploaded into Falcon. What happens next, step 2, is that care travel data. So there's a call center, and it comes from care travel data at state.gov, and an email center. Those are being sent out to people who are in that phase, and they're going to ask for additional information. So if you have clients who are getting emails from a state.gov email from care travel data, that's correct. That is what's happening. And it means that they are in Falcon, and this new system is now reaching out to get those additional things. What are they going to ask for? Some of the requirements, those additional pieces of information. Every single traveler has to have a passport. Are they a newborn? They still need a passport. So a child being born is actually they're going to have to go to the passport office somewhere, either in Kabul or in one of the provinces, or the Afghan embassy in Islamabad, although they can only do extensions right now. Every single person, 100%, it's a Qatari requirement, has to have a passport. That passport from the date of travel has to have 6 months until expiry. That's to leave enough time on the back end so that when they get to Qatar or one of the other third countries that CARE is sending folks to, there would still be able to then travel to the United States on the same passport. So and that's from date of travel. So if you have somebody who passport expires in the next year, they should consider starting to look at extensions. One of the other requirements, they're going to ask about any current pregnancies. The current care cutoff for pregnancies on date of travel is 28 weeks, which is relatively early in the process. So pregnant women generally are not flying. They'll wait until after the birth, and then you have to get a passport. There's vaccination requirements. Typically, those are going to happen in Kabul after somebody gets notified of their manifest eligibility and that they're necessarily on a flight. There's going to be appointments and things, and those are kind of picking up. There's a tuberculosis test that happens prior to flight, maybe like 72 hours out. Failure on that TB test, which we see often, will result in somebody being taken off of that flight, and then they'll go into the remanifest queue. And then the Qatari requirements, they may be asked for to send, sometimes we call it a proof of life photo. They may be asked to send a photo of themselves holding a passport or something like that. All those are usual normal requirements. The best thing is to just comply with whatever that CARE email asks for. That CARE travel data email doesn't necessarily indicate that a flight is coming soon. Once you send all those things in, you're back in kind of a waiting period. The last bullet point on the 3 steps on the process on the right says 3 weeks and 3 days. Those are general timelines, but usually after you submit everything to CARE travel data, about 3 weeks out, from a flight, you're going to get notified that that person actually is going to be on an upcoming flight. And it's going to have some instructions in there. And then I have the 3 weeks, 3 days. What does 3 days mean? One of the things is it's not always going to be exactly 3 days, but 3 days to a week before that flight is actually scheduled, they're going to get additional instructions. And those are going to have to do with the vaccinations, the tuberculosis test. They need a Qatari visa to enter Qatar, but those are applied for in bulk by the US government. But when they show up to the place in Kabul that they need to go to, there's going to be like pictures taken. They're going to collect the actual passports for in-camera inspection, all kinds of things. Again, as those come up, just comply with what's being asked, double check that the email is actually coming from state.gov. And as long as it is, whatever they're asked for are fine. There can additionally be some like WhatsApp contact from the actual contractors. There's 2 of them. They're called CPAR and Soteria. If you have any questions about the legitimacy of those or what the WhatsApp numbers are coming from, please contact the EOA Ops Center. That's what we're there for. And I'll make sure that for the handouts and the take homes that our information is included. But checking and double checking and whitelisted phone numbers and WhatsApp numbers is one of the easiest things we can do. And we're happy to do it. So if you're unsure, please just give us a contact. Next slide, please. Talking a little bit about self-affected relocation. I don't work in this thing as much, but just if you have clients who are considering going to Islamabad or another third country, I just wanted to bring up a couple of things. Usually getting documentarily qualified before you try and make that entry into a third country, I would say is best practice and a good idea. One of those reasons is because the consideration is just cost. It can be prohibitively expensive to live for a long time away from kind of folks' base of support there in Islamabad. Prices can be high. If you fall out of status in Pakistan, that can be an issue. You can end up getting exit fines. So all things to think about is how much money do folks have? Do they have a Pakistan visa? Are they even able to get into and make entry into that country? Is it going to last long enough? Do they have an interview appointment? Have they made that case transfer request? The interview times can vary widely. At the beginning of this year, in January of 2023, we were seeing interviews be scheduled for January of 2024. You'll hear anecdotes and stories of things happening much, much faster. We at the EOA Ops Center don't currently have good timelines on how long it takes from requesting an interview to actually getting scheduled there at Islamabad. It can vary widely, and sometimes the wait times can be quite long. So just be aware of that before a client necessarily tries to make it there, as they could be waiting quite a long time, and that could take money. So they could make that transfer request, try and get the interview, but then maybe even stay in Afghanistan until closer to the entry date. Exit is proving difficult. If folks have fallen out of status, they're having to pay kind of large fines in order to get the that exit permit, which they'll need before they can leave. And then we run into IOM scheduling issues. So staying in status in Pakistan to the extent possible is always a good idea. And then if you originally assigned it to Kabul and now they decide to go a self-affected route, they're going to have to make that case transfer request. Instructions are on the State Department website. They're pretty straightforward. And so you can just follow that. Next slide. Contacting the National Visa Center. Yeah, there's some different ways you can get in touch with NVC as you're in the various parts of the application. There's some ways that are pretty easy to do that. If you have questions about how to contact them for during various parts of the process, contact EOA Ops. Next slide. And that brings us to the common scenarios part. And this might be a good part, Hannah, if we want to talk about this or just go off of questions that are common scenarios. I'll hand it back off to Hannah or Becky here, and they can let us know how we want to handle this last half.
We can go ahead and take a couple of questions. It looks like folks have specific questions. If anyone has any of these scenarios that you want to hear specifically about, go ahead and put in the chat if it's bullet 1, 2, or 3. And meanwhile, let's take a couple of questions. I think looks like there's one from Elizabeth Callahan around I-824 approvals. Do they go through Falcon?
Elizabeth, I'm going to get back to you. I'm not generally all of them have been updated, but I will ask that specifically. We had a State Department engagement yesterday, but this should be known. There's a guy named Chuck. I'm going to text him and I will let you know, and I'll get your email and follow up with you. Or you can, I'll drop it in the chat, but it's Lucere P at Human Rights First. I'm not sure on that one, but I will get the on that specific one if they've made those software updates yet. Thanks for the question, and I wish I had an answer, but I'll get it for you by today.
All right, I'm scrolling up in the chat because I want to make sure I get questions that are up here earlier.
Becky, I see one from up a little bit earlier that I think is it's a good question because it's kind of it's one that we receive a lot at the support centers. And this is the one. Is it from Jamaluddin, I think? Green card holder who got his LPR in 2019 based on SIV. After receiving LPR, he has 2 more children. What is the good step to take now? And all his family here in the U.S. evacuated in 2021 with parole status. So this kind of gets back to the issue we saw earlier. If the children or if the spouse doesn't become the children or spouse until after the principal receives their residency, then they have to proceed with a new I-130 family-based petition rather than applying as a child derivative under the SIV. A couple of things to note there. Like we were saying earlier, you know, the spouse and children of LPRs in the F2A category now are facing a backlog. And this means not only do they have to pay the fee for the I-130, but unfortunately, it also means that I-130 will not be expedited. At least it won't receive the automatic expedite treatment that immediate I-130s are receiving, such as I-130s for immediate relatives. So with that in mind, you know, the I-130 might take some time. The I-130 might go quickly, but the priority date might take some time until it becomes current on the visa bulletin, which means that even though they can go ahead and submit that I-130 for the children now, they're still going to have to keep in mind, you know, what's going to happen between now and when that priority date becomes current on the visa bulletin. That might take several years. So hopefully they have an opportunity to, you know, apply for their referral and maybe another status will appear for them. Thanks. Any other questions?
Oh gosh, yeah, we have plenty of questions here as you're scrolling through. If you see something you want to jump on, go for it. We did have a request. It looks like Jessica asked, looking for it now, reviewing the options for parolees with families still in Afghanistan.
Parolees, families still in Afghanistan. So I didn't talk about it. One of the new categories that got released in I think it was June of this year, which was something we'd waited for a long time, was the DS 4317. Those are typically reserved for folks with no other current pathway to the United States and who haven't filed to adjust or for asylum at all in the United States. So I think it's going to become kind of a little bit of a legacy form relatively soon. And it's also been taken offline shortly for some updates. It was granted under some emergency authorization approval, so it was only allowed to be active for so many months and they have to renew it. So if the DS-43, I believe as of this moment, is actually currently down on the State Department website. But for those parolees, if they have filed asylum applications, then they would, once those have been granted, they can go through that I-730 process. If they're adjusting through SIV and they have filed that 485, absent an adjustment act, and while the 4317 is down, it's a little tricky, but generally finding which pathway they might take, whether that's the adjusting as an SIV, as a relative, or as through asylum, and then following those processes is going to be typically the fastest, unless there's a UAM involved. But the 4317 is something that was promoted for that exact population, but it came out a little bit too late, and now it's down, and we're not seeing a super high amount of those folks actually being manifested on flights. So I don't know if that answers the question, but finding a category for them, I think might be more advantageous for parolees who are here in the United States with family members left behind. If there's a UAM who's here, that's going to be slightly different. If it's an underage child who's left behind, that it falls into a kind of a different priority category. But hopefully that answers the question.
Yeah, thanks, Pete. And there's a related one to the DS 4317. Is there a way to get a status?
Yeah, I answered that in the chat to Charlotte.
Oh, sorry.
No, that's okay. I don't know of a way to get a status update on it right now. Like I said, it's a brand new form. And so a lot of the logistics and behind it haven't been super great yet, but it is also relatively new. So the earliest a 4317 could have been submitted was only a few months ago, I believe. And that being the case, I wouldn't necessarily expect to have heard from Care Travel Data yet on that. The backlog is quite long with SIV applicants and other folks who also tend to occupy kind of higher priority tiers. So that if you haven't heard back yet, other than maybe an auto reply, that wouldn't necessarily surprise me. I would just double check and make sure that all the paperwork was submitted correctly, so there's nothing on your end, but it might be still quite a bit before they necessarily hear from Care. Unfortunately, the wait times are all just still very, very long. So I don't know that that would fall out of the ordinary.
And just chiming in regarding the forthcoming new form that will be coming out. I did hear a rumor that part of that new portal will allow applicants to at least see that they have an application pending, which is something that we haven't been able to do yet. So we haven't seen this yet, but supposedly once you file a new DS4317, or if you have one pending, you'll be able to see on the system that you do have an active case in there, which is helpful, because sometimes you're just wondering, well, what the heck happened to me?
Okay. Great, Pete and Chris, we're running close on time, so I'm actually going to pause questions. We will keep a copy of the questions and send, and if you want to refer to them later, but let's go ahead and move to the next slide. Well, actually, as I'm looking at it, we may have covered some of these common questions about family reunification. Let me see if is there any other common questions that we don't already have in the chat. If not, we can take another question.
I see a question there from Olivia, and I think, Pete, you kind of referred to this earlier, but the question is, if family members are living in a neighboring country, such as Pakistan, without legal status, would they receive any legal protections to remain in Pakistan when they're applying for these family reunification programs? I guess the short answer is certainly not from the U.S. government. The U.S. government doesn't really have jurisdiction over, and they don't have the ability to help folks when it comes to getting legal status in third countries. So they would kind of be on their own trying to get that kind of legal status from the Pakistani government themselves.
All right, any other questions?
Just a follow-up with Charlotte. I apologize that I said it came out in June. The last 2 years have been a crazy, so my timeline is just awful. So I did not mean to be way off on that timeline. And I said I don't spend a ton of time on that DS3 the 4317, but we have some other folks who are doing advocacy around it. Drop me an email on it, and I'll see and if it matches up with other cases. I know we have folks who are working on those. I know it's a common refrain that they're not getting the auto replies or anything like that, but I haven't touched one of those quite recently. So I'll see if your timeline or if other folks have had different experiences. And if so, then maybe that'll pop as a flag, or if it lines up with other folks. But yeah, please, just drop me an email and I'll be able to take a look at some other similar cases and we'll see. If any folks have any questions about like stuff that they've gotten from Care Travel Data, or if there have been specifics like that, if we haven't, because we're going till we got 5 more minutes or anything, happy to take on those. I know it can be difficult. From Catherine, status of unaccompanied minor in Afghanistan who has passport, parents in the U.S. So the parents in the U.S., any advice on SIV denials? Yeah. For those who are in the U.S., it's going to depend on. So the unaccompanied minor is still in Afghanistan. It's going to depend on what the status of the parents are, and for the most part, it's going to go through the same way. There may be some additional considerations closer to flight time once they actually identify that child, because the travel can be quite difficult. In the past, I've seen situations where if there's not an eligible family member who can travel while that child is in Afghanistan, they look at the flight manifest. This is how it used to be done in the early days in the Wild West, so it may be different, but they'll identify a family that has similar aged kids. They'll sign a power of attorney transferring just for the time of the flight, like an in loco parentis type agreement with that family, there's a handoff of the child from their current relatives that they're staying with to that other traveling family who accompanies with them, like for the duration of the flight, usually to Qatar. And then, trained State Department folks pick that child up once they arrive in Qatar. That could be changing. We're seeing actually requests for parents sometimes who are here in the United States to travel to Qatar. So it's a little messy right now, but that's the best I can do. We've run into cases like that with underage children left behind. They're messy, and usually the best thing is to work through it's just a little messy right now. I don't have a great answer. Sorry.
Great. All right. Thank you, Pete and Chris. We're running short on time. We have about 2 minutes left. Couple of things I just want to cover. So thank you all for your questions and for the great conversation. Much appreciated. And I saw that Pete put his contact information. You can please continue to reach out with questions. I just wanted to highlight for you all some of the ILSA resources. If you're an LSP, you haven't joined our network, just to know some of the resources available to you, the Peer Networking Hub for ILSA certified providers, where you can ask questions just like the ones we've seen here in the chat, share some best practices, strategies, definitely a benefit for those LSPs. We're part of the network. We'd encourage you to leverage our Peer Networking Hub. Also to highlight, we're holding ILSA office hours. They're held an hour every other week, an opportunity for conversation and for those in the network to engage in discussions on strategy and collaborate and enhance their experiences. And of course, a lot of training materials available to you. And here is our ILSA website and our email address if you would like more information about ILSA. So with that, well, one last thing, resources. We will send this deck out to everyone at the end of today's training, so you'll have the opportunity to see these resources. It will also include our survey of today's session, which I think Hannah will also, or Bridget will also put in the chat here. There it is. So if you would take a minute and complete that before you log off the call today. And I thank you all for your time and attention. Chris, Pete, thank you very much to both of you.
Thanks so much for having us. Hope it was helpful for folks.
Yes, thank you, Becky, and everyone else on the team, and you, Pete, as well. Yeah, I dropped my email in the chat as well in case anyone has any follow-up questions. Appreciate it.
Thanks, everyone.